Pattaya City Expats Club is a non-profit social organisation and our speakers are volunteers. The club as such assumes no responsibility or liability for the professional reputation of or the quality of services provided by the speaker today.
Thank you for giving the talk and thank you for all that you've done over the club over all these years.
Okay. Skippy, if you can, there it is. Okay. Basically, my career, I was an auditor with the Inspector General's office. I'll give you just a little general idea of my career, starting out as an auditor in New Orleans, and moved around a bit, supervisor in Oklahoma City, and then Assistant Regional Inspector General for Audit in Fort Worth, culminating my career as a headquarters Director of Internal Assessment, which I won't go into any great detail on. But if I told you about what I spent most of my career doing, I'd bore you to tears. So, but I think what I'm going to share today, hopefully you will find interesting, because first of all, you can look up, these are some of the HUD programs, the 3 primary programs that the department had and funded, and the type of court cases that came out of those. My background predominantly, initially, so was in the Federal Housing Administration insurance program in what we called the multifamily area, which is apartments, nursing homes, and hospitals, which the FHA insured the mortgages. And I think maybe because it dealt more with private industry, we seem to have a lot more crooks involved with that program than we did with the others. In the case of public housing authorities and grants, we were dealing with governmental entities, so our biggest issue that we might come across there was embezzlement or kickbacks and bribery. As far as my experience as testifying goes, it wasn't, like I say, a full-time activity, but I did testify at criminal trial, which I'll tell you about, at 2 state court, civil trial, and then I did testify at some various administrative hearings, and I did spend not a lot of time, but a lot of work we did do over the years with dealing with assisting government attorneys, either in criminal cases and or civil. I mentioned being an expert witness. If you're going to be a witness, you're subject to discovery, which means that whatever you're going to say, the opposing counsel has a right to know beforehand. Assisting only, which is what I preferred if I could do that, was anything and an information I'm giving the attorney is attorney-client privilege and did not have to be disclosed to the other side. Okay, just a little bit about giving testimony. It's primarily, and by the way, I'm not a lawyer, so the legal stuff I talk about is based on what lawyers told me or what I experienced during my career. But basically you have 3 types of witnesses: a fact witness, expert witness, and rebuttal. And a person can be all 3. But the primary thing is an expert witness can give opinions, whereas a fact witness cannot. And a rebuttal witness basically, in most of the time, this will be an expert, where they rebut another expert's testimony. So, and in the process of giving it, generally it's direct testimony, then you're cross-examined, and what they don't show on the TV shows and movies is there's a thing called redirect, which means after you're cross-examined, your attorney can come back and ask you questions as to relates specifically to what was brought up during your cross-examination. And then the other attorney again has a chance to cross-examine you again on the items that was brought up on redirect. Okay, the first case I'm going to talk about, actually for the 2 criminal cases, was the housing authority of the Kiowa tribe. This was in 1976. It was in state district court, and it dealt with embezzlement. It was also my first time of giving testimony, so the first time I wound up on the witness stand, I had a very big quaver in my voice. And I mentioned that to the district attorney during the break. And he said, "Don't worry about it. At least you didn't forget whose witness you were." Okay, there were 2 trials. The first one was the executive director and her husband. The second one was the chairman of the Board of Commissioners and his cousin. Little family stuff. So we'll get into those. All right, first of all, a little background. If you notice on the map, that says former Indian reservations in Oklahoma. It's also showing the area where the Kiowa, Comanche, and Apache reservations were located. But basically, it was in the 1800s. I will mention briefly that I do have some personal stories here. The Indian tribes that were forced into Oklahoma, first of all, on the right-hand side where you see Indian Territory, these were primarily what we call the 5 civilized tribes. Their original territory was the southeastern United States until the U.S. Army forced them onto reservations in the Indian Territory. I won't go into that. It's an interesting story. And if anybody's interested, just type into your search browser, Trail of Tears. And if you do that, you'll get a lot of information about their being forced to reservations in Oklahoma. The western side of the state was mainly Plains Indians. The Indian tribes were from that area, as well as being from Texas and the surrounding area. It was during the Indian Wars that they were defeated and forced on the reservations in Oklahoma. And I mentioned a little personal history there. My brother did some research on our family, and I did find out that my great-grandfather was a member of a Texas Ranger company and fought in those Indian wars. Well, the tribes, once they were forced on the reservation, many of them slipped off the reservation and raided in Texas. Again, a little family history there is my great-grandfather had a son by his first wife. My grandfather was my second wife. When my grandfather was a baby, his older son, who was my my grandfather's half-brother, was okay. Is this okay? Is this better? Okay. Anyway, basically, the story the family tells is that the older boy was a teenager, was supposed to bring in the cows. He was delayed, and his stepmother, my great-grandmother, didn't want him to go out because it was starting to get dark. And he did go out after dark, didn't come back. They found his body the next day with arrows in it and no scalp. So, but then again, as I say, the Indian tribes, but I wanted to mention this because what I'm going to be dealing with is trust lands. The reservations were done away with in the late 1800s, and all the reservations were divided up, and a plot of 160 acres was given to all adult male members of the tribe. Once that was done, there was a lot of the land left over, and as a result, it was occupied under the Homestead Act. Okay, so the Housing Authority of the Kiowas, it was created under state law, so in essence it was a state agency that was federally funded. Now, most housing authorities were run by cities and counties, and they built apartment buildings. The Kiowa Housing Authority was a little different in that they were putting houses on pieces of land. Basically, one of their members would, low income, had inherited some of this trust land. And it was called trust land because although they owned the land, it was held in trust by the Bureau of Indian Affairs, and they couldn't lease it or sell it without the Bureau's approval. And in this case, they would make application to the authority offering a plot of their land, about an acre and a quarter, and they leased it to the housing authority. The housing authority then put a house on it, built a fence around it, and if it was in a rural area, drilled a water well. But the houses were not constructed on site. They were constructed in a factory, prefabbed, sections were brought out and put together on the house. The contractor contracted to do 450 houses, but they couldn't get the plots of land to him fast enough, had workers idle, and as a result, they went bankrupt after delivering about 220 houses. At the time he went bankrupt, they had a separate guy drilling the welder wells, and he had about 10 wells that he hadn't been paid for. Okay, well, he was the contractor. At the time he was operating, an experienced executive director, but once he went belly up, a new board of commissioners had been elected, so they dismissed the experienced executive director and promoted one of the clerks, who was a tribal member. Her name was Dorothy DeLon, and they made her the executive director. They later had a little bit of a falling out. She was dismissed, and I don't know whether it was the board member or her that went first to the district attorney, but they started pointing their fingers at each other. And as a result, the district attorney convened a grand jury, had brought in witnesses, and out of it, they indicted the executive director. She was tried, but found not guilty on one count, hung jury on all the rest. Because of the publicity, the U.S. Attorney in Oklahoma City got interested. Say Public Housing Authority, you're saying federal funds. So he asked the FBI to investigate. The FBI obtained some of the records. Then they said, we need audit help. So they contacted our office in Fort Worth, the regional office. The regional inspector general then assigned it to the Oklahoma City office, which normally was staffed with the supervisor and 3 auditors. At this time, we had 2 vacancies, so there was only the supervisor and me. Well, the first thing we did was contact the FBI, find out what have you done so far, and basically they hadn't done anything other than pick up a box of records. So we took the box back to our office, sorted through it, and we quickly realized that a large portion of records, which applied to the period where all the accusations had been, they didn't have. We asked them, where was it? They said, oh, it's in the district attorney's office in Anadarko, Oklahoma. So we met with the district attorney, and his first question was, will you testify? Our answer was, well, give us a subpoena. Okay, have at it with the records. He did say that if the U.S. Attorney wanted to formally take over the case, he would step aside, but other than that, he was going to pursue it. Well, I don't know what happened with the U.S. Attorney and the FBI, but they never contacted us again. So in essence, we became gatherers of evidence for the district attorney for his cases. Thus, the reason it was in the trials were in district court, state district court, not in federal court. Okay, I'll deal with the first trial first. There were 2 trials. It was the executive director and her husband. One of the things was she paid herself an excessive salary. I didn't recall what it was because my supervisors did that, but I did, in preparing for this presentation, did look at the appellate court, and apparently her salary was $375 a month, and she increased it to $550. But at any rate, he verified that that wasn't the case. In my case, they had to deal with the construction of a house. This is called the George Dankow House, and it had been destroyed by tornado. As a result, the housing authority decided we're going to build him a new house. The slab was already there, the water well and so forth. So they set up a separate bank account and put the money in that bank account and used it then to pay for labor materials and so forth. And my job was to look at the special bank account to see where the money went. And the reason her husband was on trial was he was hired to supervise the construction and to be paid a salary. Well, the first problem I ran into was there were no bank statements or canceled checks available because they disappeared. The district attorney told me Dorothy told him that a white tornado came into the office and destroyed just those records. Of course, that's a little far-fetched, especially since White Tornado was the name of a popular cleansing detergent at the time. But at any rate, that didn't stop the review because the bank had records. So I went to the bank and I looked through the microfilm. They only had a reader, they didn't have a printer, so I wasn't able to print them out. But basically, I'm sitting in front of the reader, rolling through a spool of microfilm, documenting all the transactions that went through the account. When I finished, basically I came up that $40,000 of the Housing Authority money went into the account, $20,000 of it was used to pay labor and materials, and $20,000 of it in various checks was paid to Dorothy's husband. And $20,000 is a little bit unreasonable when you consider that all the other costs was only $20,000. So thus, the reason he was being charged with an embezzlement as long with her for that particular money. Okay, trial. The defense attorney was very objectionable. And the reason I say that, and the district attorney warned me about it, was this particular individual attorney, the way he defended his clients was by objecting to all the testimony and the evidence. The reason being that if they got convicted, then he would get the transcript, go through it, and raise issues on appeal, and he couldn't raise an issue on appeal unless he objected to it during the trial. Okay? Well, the assistant district attorney then told me that he had his plan all laid out on how he was going to present the case, which witnesses, so forth, to provide a convincing argument to the jury. Well, as I say, the best laid plans of mice and men, and the defense attorney threw a monkey wrench, for our British folks, a spanner, into the works by the fact that he brought up that all the documents we were going to testify to had to be in the courtroom. They couldn't be elsewhere. Well, we had a lot of the records in the court, but we didn't have all of them. So my supervisor headed off to Oklahoma City to get the records we got from the FBI. One of the witnesses who worked in the financial analyst in the HUD office in Oklahoma City had formerly been an auditor. He volunteered to take the bank manager and the microfilm 15 miles away to another bank that had a printer so they could print out all the records from the microfilm. In my case, I headed off to the Housing Authority office, and I ran into the office, and what I needed was the ledger cards for each of the 220 participants, which was in like a Rolodex type file. And when I went in, I mentioned that the attorney had sent them a subpoena dugas tecum. That's a subpoena for production of documents. And it might not have been all that funny at the time, but I do recall that when I ran in, I grabbed the records and said, "You've been served with a subpoena dugas tecum, and Dukas is taking them." And out the door I went. Okay, this is just an article that appeared in the paper about that time because we had to bring in all the records. This was kind of interesting because during a break, the district attorney said, "I'm going to call you next as the witness." I said, "Well, do you want us to bring the records into the courtroom?" "Oh, no, wait till the jury's in the box." They trial attorneys do like a bit of theater. So, if you can picture it, courtroom is the judges, all the participants, the railing, much what you see in the movies. 200 spectators in this particular case, because that was about the number of seats in the courtroom. Excuse me. So, if you can picture it, tells the judge, "Call Mr. Vaught for witness." The bailiff is told to call me because witnesses couldn't be in the courtroom. We're expecting it, so if you can figure, everybody's waiting, the jury's in the box, the back door's open, and coming down the aisle are about 6 guys carrying boxes of records. As they come in, they plop them down in front of the prosecutor's table, and I'm bringing up the rear with 2 big, fat catalog cases, which contain my working papers. So I get on the stand. I'm qualified as an expert witness, which basically means that I had to give my background, education, experience, and so forth, so that I could testify as being an auditor. Here's that same article, but here's a little bit of extract from it. You can look at it. It makes reference to stacking the records, and that my testimony dealt with the Denkow house. Okay. The original testimony I gave really wasn't all that much. It was basically, it was in total. I said, I went to the bank, I looked at the microfilm, these were the records, and my total of $40,000 went into the account, $20,000 went here, and $20,000 went into the personal account of the defendants. So then it was turned over for cross-examination. Well, the defense attorney, one of the first things he said was, you testified that you had reviewed the original documents. And I said, that's correct. Well, it turned out there was one photocopy of a single canceled check in the doc. He runs over, grabs it up, and says, what do you call this? I said, it's a photocopy. He said, but you testified for the originals. I said, well, I did accept that one, and the bank apparently lost the original and sent him a photocopy. And he then objected to all of my testimony because I'd been untruthful about that particular item. Of course, the judge overruled him and told him to proceed with cross-examination. Well, the problem was he started complaining then that, that's what I just mentioned, he complains about the fact he got all these documents and he never had a chance to look at them. I think the judge was a little exasperated because, of course, he could have asked at any time before the trial to look at those records. But he said, well, it's Friday afternoon, we will recess until Monday morning, and you, Mr. Black, have all weekend to look at the records. Okay, now we're back Monday morning, and kind of an interesting thing, one of the jurors in the box was a young guy, 20s I would say, wearing a red cowboy shirt every day. I hope he changed the shirts, but anyway, it was a red cowboy shirt. But in looking at him, I had told myself, well, if anybody's going to find the defendant's not guilty, it'll probably be him. Well, on the Monday morning, as I'm coming into the courtroom, the courtrooms are upstairs, and you actually have a balcony that overlooks the lobby. And as I'm coming into the lobby, a voice booms out, there's my main man. Well, I looked up, and it was the guy in the cowboy shirt, the juror. But anyway, you don't talk to jurors, that could be a mistrial. So on to the district attorney's office I went. Okay, now I'm on the stand. Cross-examination. The defense attorney approaches me with a copy of my working papers, which we had given to him previously. He said, on Friday you testified from these records. And I said, no, I didn't. It was a shocked expression. I said, I testified from the originals. Those look like copies. He said, well, they are. I said, okay, I'll take your word for it. I'm getting my licks in. Okay. The defense attorney then put my copies on his table. He picks up his notes. He turns around and says, what would you on Friday you testified, 40,000 went in the account, 20,000 went in my client's account. Correct. He said, what if I told you I come up with different numbers, drastically different numbers? My response was, well, I wonder where you got them from. He runs over to the table, picks up the copies of my working papers, and shakes them at me and says, from the same place you did. I said, okay, I got my records here. You want to go through them? Sure. He sits at the table, and I start now listing every single check that was paid out to the defendant. And when I finished that, I said, that totals the $20,000. He said, that's what I got. And I kind of didn't say anything, but I'm sure the jury could read my expression, which was in essence, Buster, you can't add. The only other thing he did during cross-examination that I can recall is he approached me with a copy of a blank housing authority check with just the starting of a signature. He says, in your opinion, would you say that this shows somebody's practicing the signature? And I started to explain why that might not be the case. He interrupted me and said, answer the question yes or no. And I again started to say, he interrupted, turned to the judge, Your Honor, would you instruct the witness to answer the question yes or no? The judge says, told the clerk, read back the question, turned to me and says, that calls for a yes or no answer. Well, he didn't get the one he wanted because my answer was no. Of course, had I answered yes, I wasn't too concerned about it because the district attorney on a redirect could have asked me to explain it. But as it was, I said no, so it was never pursued. And to this day, I still Can you give me the next slide? Skippy? Okay. No, I'm going the wrong way. Okay. I finished up, and as far as that saying, apparently the practicing a signature, unless he was going to bring up something up with the forgery, I have no idea why he brought it up, and even if he had, I still have no idea what benefit it would have been to him because we were testifying as the money that actually went into their bank account. But anyway, I was released from the stand, but not as a witness because the district attorney told me he might want me as a rebuttal witness when the defense put on their case. So he, I went, then I was twiddling my thumbs in his office, and the following day, I'm suddenly, somebody sticks their head indoors and says, the bailiff's calling your name. I didn't expect this. I go back on the stand, remind him under oath, and the district attorney says, Mr. Vaught, would you please tell the jury why you were doing your audit? The defense attorney immediately, objection! And the judge hammered the gavel down so hard I thought he was going to break it. Overruled! Mr. Black, you've raised some questions in this courtroom, and we're going to get some answers. Of course, my answer basically was the what I've already told you about the U.S. Attorney and the FBI asking for the audit and so forth. I did ask the district attorney afterwards, what was all that about? And he said that when he was interviewing the HUD witnesses, he apparently asking them why they asked for the audit. Of course, they didn't know or why it was being done, and apparently he was giving some inferences that they somehow were lying and had it in for his clients, and thus they had asked for the audit. And he said he had then told the judge, Your Honor, I think we call Mr. Paul back. He can tell the jury why they were doing the audit. Okay, I'm barred from the courtroom. I'm still there, and I wasn't called as needed for a rebuttal witness. I had hoped to, when the defense rested, I'd be able to go in the courtroom and listen to closing arguments and the jury instructions. However, apparently the defense wasn't very long, and they proceeded on to do the closing arguments and so on. So when the district attorney came back in, he said, well, the jury's out, deliberating. It wasn't deliberating long, about 2 hours. When they came back, they had found both guilty and recommended the maximum sentence, which was $500 fine and 5 years in prison. The assistant district attorney was worried, and he told me afterwards that because of small children that they had, that the judge might be lenient and suspend one of their sentences so somebody could take care of the children. As it was, the judge did do some suspensions of the sentence, but he did require both of them to go to prison. One would go, the other one would take care of the children. When they finished, the other one would go, and the children could be taken care of. Okay, board chairman. Embezzlement, fraudulent buildings for water wells, fences, and some maintenance. The cousin shared the proceeds with the chairman. There was a big chunk of money was still left in the bank account when the contract went belly up, and greedy hands. This is an article that appeared in the Lawton Constitution. It makes reference to the upcoming trial, but it points out that the chairman, Fitzboy, and his cousin Laverne Sapethal were recalled by the tribe and lost their positions on the board. In this case, Laverne, the cousin, had subsequently been elected to the board. That's when they stopped the checks. Okay, how did it work? Basically, I scheduled out all the payments made to Laverne Civitar. I reviewed the documents, as you can see, with the invoices, canceled checks, and so forth. And then the next issue was finding a plot of land. These are scattered over 4 counties in rural Oklahoma. So I had to inspect the properties to see if the water well or the fences existed. This will kind of give you a little idea. All this land had been surveyed, and basically I had a legal description of the land, so I had to find the township, the range of the township. Once I found the township by number, then there's 36 sections, each a mile square, and I had to find a particular corner, northwest, northeast, southeast, or southwest. Once I found that, then it said it's so many feet down the section line is where the property begins. This will give you an idea. In Oklahoma, it wasn't that liberal because all section lines basically had a dirt road around them. So it wasn't a case like strolling over open country. Basically, you had these roads, and they're every mile section. So I had a aerial map with the survey layered over it. So basically, I found a numbered highway, looked at the aerial map, found an identifiable landmark, and from that landmark then, I could identify a dirt road that started off the way I wanted to go. So then it was just driving so many miles this way and so many miles that way. Getting to the particular corner, then my car had a trip meter in it. I converted the feet to tenths of a mile, clicked on it to 0, and slowly went down the road until I came to the location. Well, of course, the fact that there was no fence was very easily identified. In fact, what I found most of the time was either no fence or, as you can see from the picture, a barbed wire fence. What I was looking for, as far as the water well goes, I did have to inspect the entire plot of land looking for a capped water well. And I did find it on the ones where the well driller had actually drilled the well. But I don't recall if I mentioned that there were 10 wells that had been dug by the driller. He had billed the housing authority, had not been paid. These were the first ones that Vincent had his cousin build the authority for. The water well did exist, but Laverne's invoice was double the amount of what the well driller was charging the authority. These were generally around $1,100 to $1,300 per well, based on feet. So Laverne was charging double that, and he was getting paid, and then he paid the well driller, and he and Vincent pocketed the difference. On the one where the water well was drilled, I did find the capped well. On all the others, it didn't exist. I say, maybe it's cold outside. Well, I'm doing these inspections in February, and it's freezing outside. And as a result, I'm coat, gloves, can't make notes, but I had a tape recorder. I spoke in the tape recorder my observations, and then that evening I documented the results, sitting in my warm room in the Black Beaver Motel and listening to the tape and hearing the wind howl and being cold all over again. But as far as the roads being lonely, I did have some concerns about security. Reason being is that the current housing authority people that I dealt with doing the audit had told me that when Vincent was in charge, he had hired an individual they called a field coordinator who was an ex-convict, and his job was to beat up anybody that complained or asked a question. So, in my mind, I'm out here looking for evidence to put him in prison. So would he maybe have the same person or somebody else convince me I shouldn't look too closely? As a result, in my pocket, I had a .38 Smith & Wesson snub-nosed revolver. Now, that was illegal in Oklahoma at that time, and I did mention it to the district attorney. And he said, well, do you want a deputy sheriff's commission? I said, no, that would create a record, and I don't think my bosses would approve. He said, well, don't worry about it. If anything happens, you have to use it. I'm the one that would prosecute you, and that won't happen. Of course, nothing happened, so no issues there. In the second trial, went a lot smoother. In this case, I met with the defense attorney before the trial, very nice guy, and when the trial started, it went smoothly. He didn't require the documents being in the courtroom per se. He also stipulated to a lot of the evidence. Basically, the custodian of the records didn't have to come in and say they were authentic. He stipulated, okay, they are authentic records. Also, which was unusual, in this case, I was to give direct testimony on the water wells, then be cross-examined, give direct testimony on the water wells, then be cross-examined, and then give direct testimony on the other material and be cross-examined, which is a bit unusual, but the defense attorney agreed to it, so that's the way it went. It's a 4-day trial. I'm on the stand for 2 days, about 4 hours each day, and I have to say a lot of my testimony was boring because he wanted me to introduce the evidence. This consisted of him handing me a check, cancel check, and a invoice, my describing it to the jury. He then took it to the defense attorney, who looked at it, said no objection, then to the clerk, who had to document it and put a sticker on it and give it an exhibit number. When all that was done, then he comes back, hands me the document, and says, did you review this document during your audit? Yes. Did you take exception? Yes. Would you tell the jury why? And of course, in the case of water wells, was I inspected the property, there was no water wells except for those 10 I mentioned, and I talked about the overpayment that they paid. And there was only one real challenge during the cross-examination. And the trial attorney, or there's an admonition given to trial attorneys. Don't ask a witness a question unless you know the answer. And that is the one admonition that most trial attorneys ignore. And that happened in this particular case. His challenge was, you are a city boy. And as such, how do you know you found the right plot of land traveling all over the country, rural roads? So I think he wanted to raise a doubt in the jury's mind as to my ability to find the right plot of land. Well, my answer was, and I fired it back, I have to say, was, sir, I have you know, I was born and grew up in Oklahoma. I spent all of my youth on my grandparents' farm, summer in the farm, in Rush Springs, Oklahoma. Well, if you can see from the map, Rush Springs, Oklahoma isn't all that far from Anadarko, and it's the same type of country. Mile section roads, country roads, and so forth. So I think the jury then had some rural people from rural area there, and I think instead of detracting from my testimony, it probably reinforced it because I'm a country boy like they are. Okay, on the first day of trial, after I finished, as I was approaching my car to get it to leave, the Vincent Boyney, the chairman, approached me and says, why didn't you ask me where those water wells were? I would have told you. I didn't answer him and just drove off. The second day was the same thing. And when doing the last bit, which actually wasn't all that much, but it was basically for putting insulation or heat tapes on exposed pipes from the water wells. The water well had pipes going into the ground to prevent them from freezing. They put an insulation tape around it, and that's what these were for. Well, the first check presented to me when I was asked, do you take exception to this? No, because it would have been inconclusive. If it wasn't there, as I say, it wasn't there previously, and if it was there, there's no way to say who actually put it there. So we get to the third, that second one, same thing. The third one, did you take exception to this one? My answer was yes. Tell the jury why. I said, well, these 20 plots of land where the tapes were put is in a subdivision of Anadarko, and they're connected to city water and they don't have water wells. And a juror closest to me, very loudly, she says, "Aha!" So she knew we were going to get to the point. Also, during a break, as I was going into the break room to get some coffee, I overheard one of the jurors from my trial talking to another one. She says, "Oh, there he is now, the poor man." So the only reason I think she said poor man was probably because I had to keep describing all those documents. But at least it showed I had some jury sympathy. The testimony was concluded. I was released. Not needed to stay. The trial lasted for 2 more days. Now, I could have stayed and gone into the courtroom and listened to the testimony and so forth. However, if I did that, I would have had to take vacation time and pay my own travel expenses, which I opted not to do. We did get a call from the district attorney. When the jury came in, they found both guilty and they recommended the maximum sentence. In this case, it's 10 years in prison because of the dollar amount that was involved. And I kind of, when you told me this, I kind of wish I'd been there, because if I had been, I would have walked up to Vince and said, "You should have told the jury where those water wells were." Okay. After sentencing, during sentencing, the district attorney did tell us the judge did follow the recommendation, gave him the full sentence, nothing suspended. Okay, this is another little story of interest, and it doesn't have to do with the testimony, but I think you might find it interesting. Vincent, along with the executive director, they wanted to award a contract to do all-purpose flues for the houses. They went to a contractor near Oklahoma City in the rural area and asked him to bid on it. They'd guarantee it, and they wanted a kickback. He apparently was agreeable, but while they were there, they noticed his neighbor had a quarter horse, and they wanted to buy it. Well, quarter horse racing was very popular in the Anadarko, especially among the tribes. In fact, in Anadarko, there's a quarter horse track with a stadium for 2,000 people. So when they wanted to buy the horse, the only thing they had to buy it with was a check made out to the then executive director for around the $800, was wanted by the horse owner. And he certainly wasn't going to take a third-party check, so they asked the contractor if he would write a check to his neighbor, who was more than happy to take his neighbor's check, and they in turn endorsed the check over to the owner. Well, back then there was an individual called Paul Harold. He used to do a radio show, and he would take something from the news, look into it, and then mention it, and then say, "And now the rest of the story." Well, the contractor bid on the contract. The housing authority awarded him the contract, but it had to have HUD approval. They disapproved it, rejected it, because the contractor was the high bidder. And as being the high bidder, he had to include the kickbacks. And the check that they endorsed to him bounced. But the thing that I think, the reason I'm mentioning it, is the piece de resistance. They named the horse embezzler. Okay, next case, civil trial. In this particular case, I'll try to go through it very rapidly, but it dealt with the first audits I did in New Orleans. There were several projects involved. The first one was the construction cost of an apartment in Baton Rouge. When I did the review, I found several apparent false statements, which I referred for investigation. And at that time, our investigators didn't investigate the case. They just sent it on over to the FBI. This individual was involved with another individual on a project out of Shreveport, which also was undergoing the cost certification process prior to the final endorsement of the mortgage insurance. I reviewed that one, same false statements. All in all, I looked for these two individuals. They were involved with two other individuals for about 14 projects. And although those were under construction, there were several certifications that had already been made, which were apparently false, and those were referred. During this time, the Inspector General was doing some special reviews of various HUD offices, one of them being the Streetport office, and by the running of auditors and investigators looking for apparent fraud activities. Streetport was one of those offices, and I was on the team that did multifamily. We did have more referrals there, but one of the referrals was the HUD manager of the office for taking a bribe. It was in the single-family area, so I'm not familiar with. As a result of all these referrals, a task force was set up instead of being assigned to individual agents. They reviewed the evidence, they investigated it, and we did have a criminal investigator assigned in New Orleans who was on the task force, and basically he gave me the feedback. All of the ones I had referred were found guilty. They pled guilty. I don't think anybody went to prison, but they all got fined and suspended sentences, and they were also being convicted felons, could no longer participate in our programs. I bring this up because several years later, now I'm assistant the area audit supervisor of our Little Rock office. I'm in Washington on a special assignment, again, multifamily area, because I was known to have a heavy background in that area. And I got a call saying that I needed to meet with a Justice Department attorney in Baton Rouge the following day because I needed to testify at a civil trial. So when I got there, he handed me the working papers to refresh my memory, told me he had discussed the case over dinner. Basically, in this particular case, it involved two of the individuals that I had referred back when I did the work in '73, and these two individuals were general partners in a nonprofit owner, and the main reason for having a nonprofit is they got 100% insurance of the mortgage rather than 90. But I think because of their convictions, the project never went into what we call final endorsement. Therefore, a large chunk of mortgage money did not get paid out to the owners, who in turn had retained money from the contractor and didn't pay the contractor. Well, the two individuals who were general partners were the corporate owners and officers of the construction company, and they were suing HUD for $100,000 they hadn't been paid. And HUD was countersuing for $80,000 for faulty construction. And the reason my slide mentions common law, because normally you wouldn't sue the government because we weren't a party to the contract. However, apparently under English common law, and I think everyone here is from a country that probably was a colony of the British, and as a result, I think most will follow common law, British common law. In the U.S., the federal government follows it, almost all the states do, with Louisiana being the only state that doesn't. They were French colony, they followed the Napoleonic Code. But at any rate, apparently there's a provision in English common law that deals with equity, and this is what they were suing the government for, saying that we're an innocent third party, we due to the actions of HUD, when we relied on their involvement to be paid, not the nonprofit. Therefore, they should pay us the $100,000 that we didn't get paid. And one of the principles of that common law is that if you sue under the equity provisions, you have to come into court with clean hands. You cannot yourself in any way be a party or having some involvement or deal. And thus my testimony relating to their false statements and so forth was in essence to support the defense that they didn't come into court with clean hands. But another reason I mentioned this case, okay, it was a bench trial, no jury. When we got to the courtroom the next day, the only witnesses were the attorneys, courtroom personnel, and so on. The judge had all the witnesses stand up, raise their right hand, swore us in, and then the rule was invoked that all the witnesses had to leave the courtroom. As I was getting ready to leave, the Justice Department stood up and said, Your Honor, the government has the right to have a representative in the courtroom, and Mr. Vaught will be HUD's representative. So I sat down at the defense table and was one of the defendant. He did tell me, I was kind of surprised. He said, well, over dinner, talking with you, you're the only person from HUD that seems to have an idea of how everything fits together. So if anybody gets off base, let me know. My testimony only took about 20 minutes, and basically it dealt with the false statements I found. The only cross-examination question from their attorney was that would I not agree that this was a new program and that everybody involved in it was doing the same thing his clients were. My response being was, there's no way I can know what everybody was doing, but in the case of your clients, they got caught. But the reason I do mention it is another testimony about the cost analyst, Bill McCartney, and his testimony was to show the estimated cost for the $80,000, which dealt with some faulty construction and rails and balcony that were not up to specification. Bill started testifying as to the cost, but then he got into why the parking lot failed. Their contention was that trucks were using it as a shortcut and it was not designed to handle the weight, therefore it collapsed. Bill started testifying that when the contractor cleared the land, he didn't clear off the fillings. He just basically left the debris there, poured some fill dirt over it, and paved over it, and it didn't have a firm foundation. It was at this point that the plaintiff's attorney suddenly said, Your Honor, I object. This man's a cost analyst. He's not a construction expert. And the judge said, I was wondering if anybody's going to notice. So there was some confusion. Our attorney was going to bring another witness in, but he sat down and the plaintiff's attorney started asking Bill his questions. And again, it's one of those cases of don't ask the question unless you know the answer. Of course, I knew what Bill's background was, so I was saying this ought to be good. When Bill started testifying, he mentioned that he had an undergraduate degree in architecture. Also, that he worked in England for the Greater Council of London, supervising the construction, design, and so forth of high-rises, apartments, and so forth. When he finished, the judge says, well, I certainly think you qualified him. Since it was a bench trial, there was no closing arguments. The judge said he wanted their closing reached by a certain date. He'd make his judgment later. About a month or so after that, the Justice Department attorney called me, said HUD was not liable for the $100,000, and the contractor was liable to HUD for the $80,000. And I had two more cases I was going to mention, dealing with a criminal case. They didn't go to trial, but I was slated to testify. However, looking at the time, I'm not going to have time to get into those, so I will not mention them. But I will mention that maybe later on, I may do some more presentation, but this will deal with the Federal Law Enforcement Training Center in Glencoe, Georgia. Many people have heard of the FBI Academy. The Drug Enforcement Agency has their own academy because nobody else will accept their investigators. They're a little bit too rowdy. But all the other federal investigators of all the federal agencies generally get their training at the Law Enforcement Training Center called FLETC. I did attend a course there, a 2-week familiarization course with criminal investigation, and I think you might find there won't be a lengthy presentation, but I will mention it, and if I have time, I will go ahead and mention the two cases here that I are not going to. Okay.
Thank you, Darrel. I felt like I was listening to an outline of TV miniseries, and I was remembering various scenes you've seen on TV and in the in newspapers and on film. It's like, wow, really made you think about that and what witnesses have to go through. So do we have some questions for Darrel? It was a high concentration talk, you know, you really had to pay attention, right?
Darrel, you mentioned in one of the cases there that the jury recommended that whatever it was 10 years in prison or a fine. I've never heard that before. It's always the judge who puts the sentence down.
Sorry, are you asking why the judge?
Why the jury recommended?
Well, in Oklahoma at that time, the jury could recommend a sentence, but the sentence was up to the judge as to what it would actually be. Now, over the years, things have changed, Supreme Court deals and so forth, but in essence, I don't know if they're still doing that in Oklahoma, but the jury could recommend, and in this case, they recommended the maximum sentence.
Yeah, another question was, when you said the witnesses and the attorneys and all were sworn in, right? And then the next statement said the witnesses could not go into the courtroom. So how the hell do they give evidence?
Well, basically, there's a rule that it's up to one of the attorneys, either the defense or prosecuting attorney, can invoke it. But it primarily is that any witnesses to testify have to leave the courtroom, and they're not allowed to hear the testimony of other witnesses, which might cause them to maybe change their testimony. But it's a very common rule in the U.S. that people, and it's most often used. I know a friend of mine was an attorney that mentioned it in a trial he was in, that he was a defense attorney, and there was a question of whether or not his client could be identified, so we had him sit in the audience and invoke the rule because he, before the witness would testify, to identify his client. And he said he was shocked because everybody who had a beard, which his client did, left the courtroom except his client. So he had him hidden out in spectators, so he thought the witness might identify. They didn't. But no, it is a normal common practice and almost always asked for by one of the trial attorneys is to bar the witnesses from the courtroom during the other people's testimony.
Hi, Darrel. Thank you for a very interesting talk on your career. I mean, a very complex area. And I now realise why you're such an asset to this club, because your capabilities of organising, putting things in plain English are plain to see, and long may it happen. Thank you.
Well,
Here.
as a auditor for the government, basically our end product was a written report. So we had a lot of our auditors that were very good auditors, but they couldn't write very well, and those never got promoted. Those that went into management positions were those that could write.
All done, all changed. Well, Darrel, on behalf of us all, wow, apart from anything else, how good and important was the PowerPoint? It was really fantastic PowerPoint. It really was like, as I say, they were really like an outline for a mini-series. And a small token of our deep appreciation, the truth, the whole truth and nothing but the truth, which sounds like just one of your newsletters, really. Well done, Darrel. Thank you.
Okay, so I can take this back.
Now, yeah, just leave all that there, and we'll get some help getting you down the stairs. We're not in a hurry. Take your time. Dr. Davey, I should say.